I'm Vincent White. I'm an employment attorney, and I'm answering questions on the public site, avo.com, where they've been posted. And this individual is asking, can I sue an online game company for a false banning? Apparently, their game account was banned from the service for a period of time. The question reads like this: My friend was banned for insulting other players in the game. The ban was for 1 month, starting yesterday. About 2 weeks ago, he had introduced me to the game, and my username in the game was very similar to his. After he was banned, this other individual's username was reported multiple times to the game moderators, and soon this individual was banned as well in suspicion for ban evading, and his friend's temporary ban was extended. And he'd like to know if he can sue an online game company for this. And the answer is probably not, for a couple of reasons. So one, you're going to have to look at your terms of service. And in the terms of service, which you've probably had to agree to in one of those click roll agreements, you have to scroll down, click the whole thing that you click and you agree to it and all that. The easiest answer here is there's probably an arbitration agreement. So if you're having an issue with the company, you probably can't sue them in court. You would instead probably have to take them to arbitration. Now, I don't know that. I don't know what game you're playing. I don't know what the terms of service say. But it's very, very likely most of these click roll agreements require arbitration. Now, second to that, you're probably going to see some language in the terms of service that say they can ban people as per their discretion, right? It's not going to have some kind of hardline standard where if we catch you doing X, Y, and Z, only then can we ban you. They're probably not going to specify that. There's a good chance they're going to say, yeah, it's our discretion. If we don't feel like letting you play the game, we're not going to let you play the game. You agree to this? Oh, great. You agree to this when you downloaded the game. You couldn't install it otherwise. The end. That's going to be their take on this. And of course, what would the damages be, right? Like, you're gonna go pay a $400 filing fee in a court somewhere to sue them because they wouldn't let you play the game for a month. In the game, you probably paid somewhere between $20 and $60 for the game, right? That isn't going to make the most sense to go drop a filing fee to sue these people. And listen, your filing fee locally could be lower than that, but just generally speaking, that's on average what it is. And so for all these reasons, this probably would not be a great litigation against this company. Doesn't really sound like an issue of discrimination either based on what you're describing here. I hope this is helpful.